Assalamualaikum and very good afternoon. Dear participants, my name is Rafqat Hussain. It is my privilege and pleasure to host this important webinar. To start the session formally, I would request Mr. Adnan for recitation from Holy Quran.
أعوذ بالله من الشيطان الرجيم بسم الله الرحمن الرحيم الرحمن علم القرآن خلق الإنسان علمه البيان الشمس والقمر بحسبان والنجم والشجر يسجدان والسماء رفعها ووضع الميزان ألا تطغوا في الميزان وأقيموا الوزن بالقسط ولا تخسروا الميزان والأرض وضعها للأنام فيها فاكهة والنخل ذات الأكمام والحب ذو العصف والريحان فبأي آلاء ربكما تكذبان خلق الإنسان من صلصال كالفخار وخلق الجان من مارج من نار فبأي آلاء ربكما تكذبان رب المشرقين ورب المغربين فبأي آلاء ربكما تكذبان صدق الله خالقنا المولانا العلي العظيم.
Jazakallah. For opening remarks, I request Ashfaq Tola Saab, Vice President ICAP, who hardly need any introduction. Ji Tola Saab. Sir, आपका माइक म्यूट है.
Bismillahirrahmanirrahim. Assalamu alaikum, my dear friends and fraternity of ICAP, and especially Rafqat Hussain and Shahid Khatak, Chairman Northern Region Committee. Assalamu alaikum wa rahmatullahi wa barakatuh. I think it is a privilege for me and it is an honor for me to say a few words about this today's webinar. And I think this is high time to highlight the role of independent directors in the board of directors of any company. And I think with the corporate governance prevailing in Pakistan, I know that the real role of independent director is not being played presently, and we need to clip some wings of the board of directors in order to make independent directors more effective. I'm sure that with today's webinar, we'll be enlightened much more, and I hope that during the currency of the seminar and webinar, we will be having good questions and answers from the panelists and from the experts. Obviously, this is a good learning curve for everyone, but today, fortunately, we are meeting, we are at Islamabad, and we are meeting some government functionaries for ICAP related issues. Myself, Iftikhar Taj Saab, and Ali Latif Saab with our Honorable
Ashfaq Saab, your voice, we cannot hear you. I think Ashfaq Saab जो है क्योंकि मोबाइल से वो connected थे तो technology issue है, so we move forward as soon as we find some time and we can reconnect to them. Dear participants, good corporate governance leads to capital market development. Over the past decade, independent directors have come to play an increasingly important role in improving corporate governance and ensuring corporate pursuit of ethical practices. We have arranged this important session to discuss importance, role, responsibilities, and liabilities of independent directors. This session is also live on ICAP Facebook page, and you can join us there as well. For welcome address, I request Mr. Jahandev Amin, Chairman CPD Committee, Rawalpindi and Islamabad. Mr. Jahandev, over to you.
Thank you very much, Rafkat Sahab. Indeed, it's a pleasure. Bismillah ar-Rahman ar-Rahim. Nahmadahu wa nusalli ala Rasulih al-Kareem. Rabbir hamhuma kama rabbayani saghira. Amin samamin. Grateful to Northern Regional Committee, our chairman, Mr. Shahid Khatak, for parting the vision. Mr. Rafkat Hussain, Chairman CPD Committee Lahore, for understanding the importance of this very relevant topic, and personally grateful to Wasim Ahmad Khan Sahab and Zora Sarwar Khan Sahaba for taking out the time in these testing times for this important seminar, important webinar that indeed is going to play a pivotal role towards our membership, our students, and the appetite for learning the new things that of course we all carry as professionals. Very grateful to the learned panelists, speakers, and the organizers. Can't say more on that because for any emerging market and economic countries, corporate governance plays a pivotal role. It's important public policy subject as well. The corporate governance reduces emerging market vulnerability to financial crisis. It reinforces the property rights, reduces transaction cost, and of course the unparalleled and unending expectation of the stakeholders, be it the shareholders or the regulators or the investors. They all look forward to appropriate corporate governance, the way the organizations are being run and governed. And it's our pleasure that we have some thought process going on in our country. And of course, although it's been pretty late, but nonetheless, it's never too late to catch up with the best practices. We know the OECD in all jurisdictions has recommended the requirement for the presence of independent directors at the board levels. Given that the refinement process is ongoing, the expectations that PSX has in this respect, the expectations that AOB has, the expectations that SECP has, and above all the public at large, because they are the ones who are the ultimate beneficiary of all governance. So with this, really grateful to our learned speakers for taking out the time. We very much eagerly look forward to them, and grateful to Ashfaq Tola Sahab and Latif, our Vice Presidents, for taking out the time for today's session. Thank you very much. Over to you, Rafkat Sahab. Thank you.
Thank you, Jahandev sir. Dear participants, as per Section 156 of the Companies Act 2017, SECP may provide for framework to ensure good corporate governance practices, compliances, and matters incidental for companies or class of companies. SECP issued Listed Companies Code of Corporate Governance Regulation 2019. The 2019 code is based on comply or explain approach, except certain mandatory requirements. Mandatory in relation to the code means such provisions that are to be strictly complied with by the companies, and non-compliance of such regulations leads to penal proceedings. Most of the provisions regarding independent directors are mandatory in nature. SECP over a period has strengthened presence and role of independent directors in listed companies. What are overall requirements, role, responsibilities, and liabilities of independent directors in case of listed companies? To discuss that, we are honored to have with us Ms. Zora Sarwar Khan, Joint Director at Education Department, SECP. Just a brief introduction. She is an associate member of ICAP and presently working as Joint Director at Education Department of SECP. Her professional career spans over 15 years with extensive experience in corporate law administration, corporate governance, and public policy. She is also a presenter and certified director. She has represented SCCP on national and international forums and enjoys synergy with stakeholders on issues related to risk management, inclusive boards, and sustainable governance. Now I request Ms. Zora Sarwarhan for her keynote presentation. Ms. Zora, over to you.
Thank you very much, Rafkat Saab, and all the panelists for inviting me here on the session on a very important topic of independent directors. And as the panelists have given a brief overview that due to corporate governance, this phenomena of independent directors has gained much importance during the last years. I would start with the presentation. So I'll start with a very basic definition of what we have, what we are already aware and we've been learning through our qualification experience at business schools and also during our professional qualification. A director is basically a part of a collective body of directors called the board, and it is responsible for supervising, control, and direction of a company. The conventional role of a board is seen to ensure that the relevant strategies are in place. The major transactions are overseen by the board, and also requirements of the relevant laws, regulations, the statutory requirements are ensured that they are complied. Apart from that, recently certain soft issues are also under the role of a board. For example, diversity policy, inclusive boards, and also equal opportunity to disabled or differently abled people in the business. And apart from this conventional role, stakeholder interest is also one of the key role of the board. And the phenomena of independent directors basically evolved from this important role of protecting the interest of stakeholders. And for stakeholders, it includes minority shareholders, it includes the creditors, and also basically those stakeholders which are not normally represented on boards. This is a pictorial view of how traditional board of directors responsibility is seen, with the governance objective divided into the impact, oversight, and succession. Under the impact objective, the board role is to see that the long-term and short-term planning of the board is in place. There's a place of a proper framework for managing the risk. Resource allocation is appropriate. Secondly, how this strategy is being executed. That is building proper leadership team, ensuring there's accountability, proper controls, and risk contingency plans are in place. This execution then is to be executed by a proper team, and board of directors basically oversees how the succession process within the business, as well as a succession process of the board themselves, is being done. And sustainability, general sustainability of the organization, and reviews of mergers and acquisitions are also one of the key roles of the board. And this succession planning requires transition. So the key role of board of directors is to ensure that the incoming and outgoing CEOs, executive directors, are smoothly transit towards change. and the board members also oversee the evolution of the board members of the board of directors themselves. And as we talk of the evolution, the digital ready board of directors, the role of board is increasingly important nowadays due to the digitization, which especially during the last 1-2 years owing to COVID has gained a lot of importance. And this has made changes to the role of board, that is in strategy. The digital business strategy is also now one of the key roles of the board. Then similarly in execution, it is important for the board to understand and be able to see how the company will shift to new digital ways of working, and realization that how their own business model is compatible with the new digital business models in place. Then in transformation, it is important how the shift would occur, and the relevant leadership within the business operations and at the board who would lead the transformation. And then again, of course, the transition is that the board needs to give significant time, resources, and ensure that the source of disruption is properly catered. Now, generally, this is a general composition of board which we see, where they're divided into inside and outside directors, which we generally say executive and non-executive directors. So, executive directors are those directors who are sometimes also called whole-time directors, but generally those are the directors which give considerable time, are involved in the operational part of the business. For example, the CEO. Then the outside directors are non-executive directors, which are further categorized as non-executive and independent directors. So a non-executive director, so independent director has to be a non-executive director, but all non-executive directors are not independent directors. And the difference I would explain in later slides. So the question is that who is an independent director? In simplest form, an independent director or director on a board of a company who is not dependent first on someone and secondly on something. Precisely who and what is someone or something it determines the definition of the independent director, and there's no universal definition. However, there's a common denominator of all the independent directors. They have to be non-executive. However, all non-executives are not independent, just as I mentioned. Secondly, definition also depends on the context and function that the director is supposed to fulfill in each jurisdiction. The main task of independent director is to monitor that the management as a means to solve the classic agency conflict between the managers and dispersed shareholders. Agency conflict is basically the conflict that the board is overseeing the interest of the shareholders. So the conflict that the board tends to benefit at the expense of the shareholders, that is the agency conflict. And the independent director ensures that this agency conflict is minimized to the extent possible. And secondly, the most famous is that protecting minority shareholders against a controlling shareholder or the block holder, however you assume. Now, there's a little historical perspective of how the independent director concept was basically merged. So in 1970s, there was a shift from managerial model to a monitoring model. And managerial model is basically the model where CEO or the majority shareholder tends to appoint the major directors in a company. And monitoring model refers to the presence of independent and non-executive directors. So in 1990s, major breakthrough was made when the Cadbury report on corporate governance was made public. and it forms the basis of the OECD principles, which I would explain later. And during that time, there was also in the King's report, which is basically applicable to Johannesburg's stock exchange companies. But both these reports are considered important milestone in enabling independent directors on board. And in 2000s, independent directors on listed companies started to be appointed. Then there was, in 2015, there was European Model Companies Act. And one of the most significant change was the OECD Principles of Corporate Governance in 2015. Although the initial principles of governance started in 1992, then in 2004, but in 2015, basically the G20 leaders endorsed the principles, and they are basically known as the foundations of corporate governance practices now prevalent in major jurisdictions. And as per their report, by 2016, virtually all major Asian jurisdictions had some kind of rules or requirements for appointing independent directors on boards. Those requirements would either be through statutory company law or through in their listing regulations or in specific codes. Now we come to the point as to how concept of independent directors emerged in Pakistan. So as you all know that the corporate governance regime, basically the first code of corporate governance for listed company was introduced in 2002. And apart from other requirements, with perspective of independent directors, it was required that there should be at least one independent director on board, and test of independence was given. The test was basically that there shouldn't be a dependency as per to the conduct and the relationship, and I will elaborate on that test later. Then in 2011 and 12, there was a very comprehensive review of corporate governance regime, corporate governance code, and Code of Corporate Governance 2012 was issued, which was made part of the then KSC listing regulations. The code 2012 required that the independent director should be at least one and preferably 1/3. And secondly, the test, along with the test of independence, circumstances were also provided in the code, which circumstances, the presence of one or more circumstances would denote that the specific individual cannot be an independent director. In 2017, as you mentioned earlier, that after Companies Act, Companies Act was promulgated in May 2017, and there was a specific section in Companies Act, Section 166 of the Act, that required that an independent director means a director who is not connected or does not have any relationship, whether pecuniary or otherwise, with the company, its associated and holding companies. So this definition was now made part of the Act. Secondly, Section 156 of the Companies Act was added, which provided that the Commission would make regulations for corporate governance. Therefore, Listed Companies Code of Corporate Governance 2017 was issued, and these regulations were based on rule-based model, or what you can say is mandatory compliance model, that all the requirements were mandatory. And then after a review during 2017 and 18, in 2019, Listed Companies Code of Corporate Governance 2019 was issued, which was based on comply or explain model. So as mentioned earlier, that certain provisions were mandatory and the remaining provisions were based on comply or explain model. The requirement of independent director remained mandatory in 2017 as well as in 2019 regulations. And the presence, role, and responsibility of independent directors from 2002 to 2019 has definitely strengthened. The Companies Act, Section 153 basically provides the ineligibility of certain persons to become director, and this is for becoming a director ineligibility. So this means a person who's not a minor or insolvent or unsound mind or convicted or debarred from office or does not have an NDN or is not a member or declared defaulter by court or is involved in a brokerage business or is a director, sponsor, or office of brokerage firm. These are the ineligibilities which are listed for a person to become a director. And secondly, the term of office of directors is 3 years with casual vacancy to be filled by the directors. So now we come to the most important definition of what is an independent director. So Section 166 defined that an independent director means a director who is not connected or does not have any relationship, whether pecuniary or otherwise, with the company, its associated companies, subsidiaries, holding companies, or directors. So this part relates to what I mentioned earlier, the relationship with someone. And now the part which says about something is that he can be reasonably perceived as being able to exercise independent business judgment without being subservient to any form of conflict of interest. So the whole test of independence enumerates in context of the relationship of that person and the conduct of that person. And this is the major key guidance which should be foreseen in when we determine what is an independent director. Now, Section 166 also inferred to certain circumstances, the existence of which would basically be considered as the person not being independent. And this circumstances are not conclusive. So there may be other circumstances which affect or which affect the relationship and conduct test of independence, but are not listed there. So the circumstances which are listed is that a director shall not be considered independent if he or she is an employee of a company, subsidiary, holding company within the last 3 years. And this period is for 2 years for public sector companies. Secondly, if a person is or has been the chief executive officer of the subsidiaries associated company holding in the last 3 years. Again, the period is for 2 years for public sector companies. Thirdly, he or she has had within the last 3 years a material business relationship directly or indirectly as a partner, major shareholder, or director of a body that has a relationship with the company. So this actually circumstance attracts the relationship as well as the conduct test that is prescribed earlier. Thirdly, if the person has received remuneration in 3 years preceding his or her appointment as a director, or received additional remuneration apart from director's fee, or has participated in company's stock option or performance-related pay scheme, such a person is also not considered independent. And then the close relative of company's promoters, directors, or major shareholders. Then if he has a cross directorship or he has served in board for more than 3 consecutive terms. This term is 2 consecutive terms for public sector companies. And the cooling off period is given as 1 term. So a person who has served on 3 consecutive terms in a listed company, after lapse of 1 term can again come on the board as independent director. Then a person who is nominated under Section 166 and 165, these sections basically relate to nominee directors, either nominee of government or special interest. And an independent director in case of PSC shall not be in service of Pakistan or any statutory body or any body or institution owned and controlled by the government. Wasim Saab would elaborate more on the rationale why this was added. Now, the number and role of independent directors is elaborated in corporate governance regulations. as I said earlier, the minimum number of independent directors under Code of Corporate Governance 2019, which is prevalent right now, is 2 or 1/3, whichever is higher. And the rounding off has been made on comply or explain basis. This basically means that in a board of 9, the calculation is quite simple, that 2 or 1/3 means that 3 would be the higher number. But in a board of 11, the company would have, for example, if the company chooses to have 3 directors, then the company would explain why it did not have another director due to the rounding effect. And that another director does not attract penal provision. So if it does not have 3 directors, at least, that would attract penal provision. But if it has 3 directors, it can explain why it did not have the 4th director due to the rounding effect. Now, declaration of independent director has been made mandatory, and this is one of the most important part of the regulation as well as law, because the independent director basically declares that he qualifies the criteria as prescribed in law with respect to the independent director. Through this, the independent director takes the responsibility of not only acknowledging the requirements of law, but also accepting the knowledge of what the requirement of law is. So this is one of the most important requirement in corporate governance regulations. Thirdly, corporate governance requires certain committees to be made, and audit committee is a mandatory requirement. So as per the corporate governance regulation, the chair of audit committee has to be an independent director, and there should be at least 3 members who would be independent, who would be non-executive directors, and the chair, being the independent director, basically poses extreme responsibility on the independent directors, because audit committee is one of the most important committees in the board. And thirdly, there's a requirement that the audit committee should have at least 1 member who is financially literate. And by financially literate, it basically means either he's part of some professional institute or has a considerable experience in the audit committee or senior management with respect to finance. Thirdly, the HR committee is not a mandatory requirement. However, it is recommended that the companies make an HR committee, and the chair of such company is recommended to be an independent director, another very important committee. Then chairman of the board, if independent, cannot be the same person as the chairman of the audit committee. And then there are general requirements which apply to all directors, including the independent directors. That is the directors training. There's specific threshold of directors that need to be trained. However, considering that now it's a comply and explain basis, and a considerable proportion of directors are already trained, the companies normally explain if certain directors have not been able to complete the directors training program. And then directors orientation is also made mandatory. It is at the discretion that how the company manages it. The purpose is that when the directors join a company, then they are aware of their legal, their business related responsibilities when they're joining the board. And then the mandatory requirement for the company is to give a statement of compliance with respect to the corporate governance regulations. And the statement of compliance is the format is given in the Code of Corporate Governance regulations. But the purpose of statement of compliance is that not only to ensure that the mandatory requirements are complied, but also to facilitate or give autonomy to companies to be able to explain in the manner that seemed fit to them as to what requirements they weren't able to comply. So Section 166, which relates to independent directors, there are other requirements as well with respect to independent directors. One of the key requirement is that when a company selects, where an independent director is being appointed under any law, such independent director has to be selected from a data bank. And that independent director is eligible and willing to act as independent director. Now, the data bank is stated to be maintained by any institute, body, or association as may be notified by the Commission. And in July 2018, Pakistan Institute of Corporate Governance was notified as the data bank for maintaining the required data bank of independent directors. And subsequently, OPF was also notified as body for maintaining data bank, but generally the data bank of PICG is referred for selection of independent directors. The important requirement for selection from data bank is that consent in writing is achieved from the independent directors when they are being selected. And then, as I mentioned earlier, the responsibility of exercising due diligence before selecting a person from the data bank now rests with the company or the government, whichever is making the appointment. So at one place under the regulation, the independent directors are giving a declaration of independence that they're aware and they are complying with the requirements of the definition of independent director, which is given under the law. And under Companies Act, the responsibility of due diligence is now on the company or the government, whoever is making the appointment. Another important thing is that under the Code 2012, the independent directors were appointed. However, Section 166 provides that the independent director of a listed company shall be elected. And the statement of material facts with the notice of the general meeting in which the election of directors are held, the company will provide proper justification for choosing the person as the appointee or nominee for independent directors. And then there was the question of the law requires that the manner and procedure of selection of independent directors should be specified through regulations. So a very short piece of regulation is also in place, which is known as Companies Manner and Selection of Independent Directors Regulation 2018. It basically provides the key features which are sought from an institute when they are acting as a data bank, and which basically comprises that it requires that the data bank should provide the proper details, contact details, name, qualifications. And the data bank is placed on a website which is accessible, searchable, and downloadable for the companies as well as the persons who are willing to be inducted in the data bank. And then there should be express criteria and procedure for applicants to be able to enter their details in the data bank. And if you go through the website of PICG, you will notice that they have a separate tab for registration, and it's a very easy form of registration. Then the regulations also provide the minimum eligibility for inclusion in data bank. So a person having graduate degree or is a member of professional body and has 5 years experience relevant to company's business, or a person having at least 15 years of experience, plus is willing to serve and confirm that he is able to commit the appropriate time, such a person is eligible for inclusion in data bank. And it was provided in the regulation that directors training program should be completed by such independent directors after appointment. And again, the responsibility of accuracy of the person is placed on the person who was inducted in the data bank, who has entered his or her information in the data bank. Now we come to what are the roles and responsibilities, duties of independent directors. So in general context, if we see that independent directors is basically there to give a constructive contribution and constructively challenge the strategy, the manner in which the company's strategy is being framed. Secondly, an important part of independent directors is that they themselves should be informed about the company and environment in which they are operating. Thirdly, another important duty is that they should refresh their own skills. Hence, the directors training program was also required under the corporate governance regulation. One of the key important factors for independent directors is that they should be able to satisfy that the financial information is accurate and risk management is in place. So the independent directors as the chair of audit committee is one of the most important person who is ensuring that this duty is fulfilled appropriately. Thirdly, the duty of an independent director, just like any other director, is to attend board meetings and give sufficient time to the agenda. And in case of any concern on any matter, ensure that their views are properly heard and are recorded in meetings. So any views that are given in corridors or privately dissent is not required from an independent director. Then another duty of independent director, and as for any director, is to attend the AGM and discuss issues related to their own roles, whether as independent director or as committee members. And thirdly is to moderate in case of conflict of interest situation. So corporate governance regulation 2017 had actually a requirement where it was required that in case there is a matter where there is conflict of interest between the directors, the presence of two independent directors was made mandatory. And of course, there was a lot of hue and cry over this, and that requirement was removed. However, it would have been one of very important requirement under this scenario. Then there's acting within authority and assist in protecting interest of stakeholders. So what if we go through the important cases or scandals with respect to corporate governance, we would always see that the role of independent directors has been highly criticized, because not only have they failed to protect the interest of the stakeholders, including minority shareholders, but they did not act within the authority and the relevant time when matter was placed before them or at the time of approving the specific matter. So it is very important that they act within their authority and act at the relevant time. And as for any director, it is important that they ensure that there's confidentiality and good governance policy is being maintained and practiced throughout the board. With respect to Companies Act, there's a specific section known as Section 204, Duties of Directors, which provides a brief overview of what are the duties of directors. And in that aspect, the first requirement is that they should act in accordance with Articles of Association, which are also known as rules of business. Then they should act in good faith and in the best interest of all the stakeholders that I've elaborated earlier as well. And they should discharge their duties with due and reasonable care, skill, and diligence, and shall exercise independent judgment. Fourthly, shall not involve in direct and indirect conflict of interest, present or perceived. So a lot of queries that we receive from companies or from independent directors is that they argue that there is no conflict of interest present. However, the word perceived means that even if there is a perception of the person being conflicted, that is also the duty of the director to not be involved in the decision making of such matter and also to disclose that interest. Then there's shall not achieve or attempt to achieve any undue gain or advantage. And if such gain is made, he or she is liable to pay an amount equal to that gain to the company. And of course, he or she shall not assign their office. And if there is any assignment, that shall be void. And any breach of duty, default, or negligence by a director in contravention of articles of association or any of its policy or decision may be ratified by the company through a special resolution, and the company may impose any restriction. This does not include breach of duty or default with respect to law. So this is an important. So how is liability of directors seen generally? So a liability of director is attracted through various methods. First is there's a liability towards the company. Then there's liability towards the third party. There's liability for breach of warranty. Then there's liability for breach of statutory duties. Then there's liability for act of other directors, and then there's criminal liability. So liability towards the company basically includes breach of fiduciary duty, any ultra vires act, negligence or malafide acts. With respect to third parties, it relates to any fraudulent trading or activity in which the director is involved, or any commitments which are made in prospectus, because a lot of stakeholders are looking at the prospectus. Then, with respect to breach of warranty, breach of warranty basically enumerates from contracts. So any express or implied contract of warranty, if that is breach, there's liability for the directors. And then there's the stated act of statutory duties that they have to comply with the relevant laws. Then the liability for acts of directors. So any director who is a party or gives consent to any decision, he is also liable for the acts of other directors along with his own. And then there's criminal liability, for example, if there's a dishonored check or there's some non-observance of law that attracts criminal liability. Now, Companies Act Section 181 basically provides protection to independent and non-executive directors, which states that an independent and non-executive director shall be held liable only in respect of such acts of omission or commission by a listed company or a public sector company which had occurred with his knowledge, attributable through board process, and with his consent or conveyance on where he had not acted diligently. So as I said earlier, if you are party to the decision or have given consent, that person would be liable for their acts. However, otherwise they have been protected under this section. And for the purpose of this section, non-executive director has also been defined, that he is not among the executive team members, is expected to lend an outside viewpoint, does not undertake to devote his whole working time, and is not a beneficial owner of the company or its associated undertakings, and does not draw any remuneration from the company except the meeting fee. And this nevertheless applies to the non-executive director definition, which we otherwise also consider. So as we were talking about OECD principles forming the very basis of good practices around the world, in 2018, World Bank's report on observance of standards and code, known as ROSC report on corporate governance for Pakistan, was issued. The report basically assessed 5 areas, which included the commitment of public and private sectors to reform, the shareholders' rights, the disclosure and transparency measures undertaken, the composition and quality of board of directors, public sector companies. So that report in general assessed that Pakistan has broadly implemented against the OECD principles of corporate governance, and 20 principles were considered fully implemented, 33 were broadly implemented, and 66 principles were partially implemented, and 3 were not applicable. In addition, it was acknowledged that the corporate governance reforms were hugely strengthened due to the update in the Companies Act in 2017, then Code of Corporate Governance of 2017, and updates to Public Sector Corporate Governance Rule 2013. With perspective of corporate governance regulations, certain recommendations were made regarding non-financial disclosures. And in view of those recommendations, in 2018, certain amendments were made to Corporate Governance Regulation 2017, which are still in place under 2019 on the basis of comply and explain. And those changes were basically related to policies to be placed on website, which includes diversity policy, corporate governance policy, environment policy. And secondly, it also about information of the TORs of the committees should be placed on the website. And because it's on comply and explain basis, so you'll find that certain companies have complied with the requirement. And after the ROSC report, basically, there was also a shift of model of compliance from rule-based model to comply or explain model. And of course, the input from the stakeholders was also a major part, especially with respect to ease of doing business and reducing the cost of business. Now, before I stress on the role of independent directors, I think a lot of you have heard already about the Enron, famous Enron scandal, which was a huge scandal in the USA. But it basically acted as the stimulus for the need of independent directors. And there's a very short video after which we can discuss what actually were the repercussions for corporate governance.
Enron used to be the second largest corporation in the United States. At one point, valued at over $70 billion. As of 1997, however, they started losing money and accumulating debt. Instead of admitting their mistakes and making changes, Enron executives decided to hide the losses through accounting tricks because they didn't want the Enron stock price to go down. Risky decisions kept being made, and the truth was hidden under the rug. As of 2001, however, the media started wondering whether or not Enron was overvalued. This obviously put a lot of pressure on Enron stock prices, which used to be as high as $90.75 per share. Insiders decided to cash out and started selling lots of shares, and prices kept falling until they ended up at below $1 in late 2001. In December 2001, Enron ultimately filed for bankruptcy. Approximately 20,000 jobs and $2 billion in employee retirement funds were lost. Many executives were brought to justice, and some of them ultimately ended up receiving prison sentences. Enron was an early example of just how recklessly some corporations are managed. We then had countless other examples, mainly in the financial industry, especially after the Great Recession of 2007 to 2008. Do you see a pattern?
So apart from the fact that Enron was duping the regulator at that time by resorting to off-the-books accounting practices, what is important in this is that, and which is not mentioned in the video, but if you go through the case, you will see that the biggest problem emerged because in 1999, the Enron's board waived conflict of interest rules to allow its CFO to create private partnership to do business with the firm. And these partnerships appear to have concealed debts and liabilities that had a significant impact on the debacle of Enron. Secondly, this Enron collapse also raised the issue of how to enforce the director's capability and to challenge questionable deals through corporate managers. Thirdly, a very prevalent observation in this scandal was that the CEO handpicked the executives on the board, and the executive directors, as well as the independent directors, were actually drawing remuneration in form of consultancy fees of firms that they were beneficially owning themselves. So, and of course, the role of audit committee is very much highlighted through this scandal. So what happened was that in 2012, George W. Bush was the president. He signed a law known as Sarbanes-Oxley Act. And this is one of the major acts which heighten the consequences of destroying, altering, or fabricating financial statements and for trying to defraud shareholders. But this law also required that companies' board of directors should become more independent and monitoring the audit committees and replacing the poor management. And this was the base of what we have seen now in form of principles of corporate governance as well. So with that, we go to the next slide as to determine that are the independent directors really performing and perceived to be performing as expected, or are they standing on one side? In context of Pakistan, before we go, I think we can go through certain factors when we evaluate this question. This includes the first factor is board influence. And the most important factor prevalent anywhere in the world is the factor of capitalism. Companies are a product of capitalist system. And it requires that the capital is from the majority shareholders. So the influence of the majority shareholder being controlling the board is in itself is the biggest influence that will determine how the independent director performs. Secondly, the aspect of human psychology. Apart from the fact that the majority shareholder is on the board, generally the individualistic approach to our transactions or to dealing with people is very much the factor. So someone also joked that in subcontinent there's a reason why cricket is more popular than football, because in cricket there's only the bowler and the batsman, but in the football you have to pass the credit, there's the teamwork. So this factor also is important in determining how the independent director would perform. Then there's a general culture within the subcontinent as well, which is different than what we see around the world. Is of respect to our elders, the notion that we should adjust and manage ourselves. This highly influences how independent directors can speak up independently and voice their concern or their dissent. And most important is when there's a family business with 50, 60, 70, 80% shareholding with the CEO and the executive directors, it is very hard for independent directors to have control, have protected the interest of minority shareholders. But again, it's a very hard deed. Then what value addition do you actually expect the independent directors to bring? Not only on part of the independent director, but what does the board actually think that the independent director would be bringing in? That also hugely influences how independent director perform. Then, as I mentioned earlier, there's this concept of groupthink. If the CEO and the executive director present a plan or any matter, present the matter before the board, and the majority of them are complacent with it, it is very hard that one person stands up and evaluates every time how well that particular proposal is being made. And generally, we go by how the group thinks. Then most important in any situation is how the dissent is seen by the board members. Is it seen as a threat, or is it seen as a constructive addition to any of the matter? Then bringing wisdom to decision. So there's a hierarchy that is well known, that there's data, there's information, there's knowledge, and then there's wisdom. So while we have experts for data, then we have experts for information, where we have very grand, colorful presentations with the flashy IRRs. How that specific proposal is seen by the independent director, and how he brings wisdom to the decision making rather than being carried away by those flashy planning presentations. So keeping in view these factors, we'll critically just briefly analyze, do independent directors in Pakistan actually are performing as per the expectations? So the first question would be, do they adequately question controlling shareholders? Largely, if we say that the situation is discouraging, that is untrue. We have cases where independent directors have questioned the controlling shareholders, but however, there is need to for independent directors to be aware of their responsibilities and question more and more. Then were there really voice of stakeholders not in the room? So we have cases where independent director has vocally supported the role of minority shareholders, or the shareholders which are not in the room, as they say, by criticizing the decision, and those decisions or dissent has been communicated to the commission, and which were helpful. So yes, there are instances where these independent directors have performed their roles. And thirdly, do they bring wisdom to decisions? And no doubt, if you see generally the independent directors, we do see that they have the ability to bring wisdom to the decisions. However, because of the certain factors which we said earlier, the demonstration of those independence and bringing wisdom is yet to be seen completely. Then there's no doubt that they possess integrity. And I've already discussed the courage part, but I would definitely say that, if there's courage, it basically, courage is a virtue, as Churchill said, courage is virtue, the biggest virtue of all the virtues, because if you have courage, you are able to, perform other virtuous act. But if you're not courageous, the fear basically comes over, and then you won't be able to speak up for what you really, the fear of being ousted would always be there. Then there's the thing that, are their performance evaluated? Although there's debate as to if performance of the independent or any director should be evaluated, or the performance of the board of the board should be evaluated. But yes, there is a certain evaluation, but we are kind of going around of how what would be the best way these evaluation could be made. Now, what is the opportunity of professionals like chartered accountants to join as independent director? So firstly, as I said, there's increased awareness about the role and responsibilities of independent directors. And this seminar is a testament to that fact, that it is no longer something which is alien to corporate sector, as well as the professionals. Then secondly, the legacy directors, as you say, there's a second or third generation of the prominent, controlling shareholders, who themselves are educated, are well informed and flexible enough to understand what is the role of independent directors in boards. And that very much facilitates or gives the opportunity of professionals to join as independent director. One of the most important, I think, aspect for encouraging independent directors, professional as independent director, was the requirement of registration in data bank. And this has not only facilitated the aspiring directors, but also the companies, that they have a readily available data bank where they can access and see what kind of skill set they require. Then, of course, there's the regulatory responsibility, because there's a regulatory requirement, and professionals are very well aware of their responsibility as per law and as per their professional ethics. So professionals basically are very much fit for the job, as they say. Then there's expectation of professional conduct from professionals, as we see that a lot of independent directors, chartered accountants are very well respected because of their professional conduct. And then there's a general reputation and national business exposure, which forces the companies, especially the listed companies, to ensure that the composition of board is appropriate and they have well qualified people as independent directors on board. And most importantly, the role of digitization has somewhat put spotlight on how the quality of the board itself, and how they sail through this disruption and be able to have proper professionals on their board, so that they can cater to any crisis, or and also to be able to embrace the new digitization era which companies are facing. Now, in the end, this is just a small overview I just had, where you can see that this is 2017 data. It's about as I said, the legacy shareholders. There's also legacy independent directors. So there were directors who were there forever, and they considered themselves an independent director. Not that their qualification or experience was questionable, but after a lapse of certain time, you cannot say that they have remained independent director. And this was somewhat broken when even in the Indian law, there was the requirement of term to be eligible to remain independent. So there hasn't been much research for Pakistan, but I'm sure that the independent directors, largely the independent directors which we see, are highly experienced, and it would be a good mix if young professionals join the independent directors and give a fresh, fresh breath of air to this corporate governance model. And this is it from me with respect to listed companies.
Thank you, Dora. Thank you for sharing comprehensive overview of government's role, responsibilities, and liabilities of independent director in case of listed companies in Pakistan. Dear participants, public sector corporations make up a sizable portion of our country's business enterprises, in spite of significant privatization that successive governments have undertaken over the past 2 decades. The government even today is by far the biggest equity holder of companies listed on our stock exchanges. The government also owns several other business enterprises that are not even listed on stock exchanges. Altogether, these assets are sizable and of huge public interest. The principal task of governing an enterprises rests with the board of directors and not with the shareholders, big or small. The shareholders, however, fully empowered to appoint and under certain conditions even can remove the appointed director. Going back some years, the government mostly appointed serving bureaucrats and executives of the concerned enterprises on the board of these public sector companies. But what has changed over the period, and what overall requirements, role, responsibilities, and liabilities of independent directors in case of public sector companies in Pakistan? To discuss that, we are honored to have with us Mr. Wasim Ahmed Khan, Director, Company Law Division of SCCP. Just a brief introduction of Mr. Wasim. Mr. Wasim has done his Master in Public Administration from Quaid-e-Azam University, Islamabad, and possesses more than 25 years of experience in areas of finance, management accounting, central banking, and corporate governance. He is presently working as director with the Company Law Division of SCCP. He also served as member on the Public Sector Committee of ICAP and is presently a member of task force formed by the federal government on framing of state-owned enterprises law. Now I request Mr. Wasim for his keynote presentation. Mr. Wasim, over to you. Mr. Wasim, can you hear us? I think due
He
to
was
technology,
around. I think he just got disconnected.
I will wait for a few minutes and he will be back. He is just connecting and we are just waiting for a few minutes. We can hear you. No, see you, sir. Jeev Singh, sir. Dear participants, with our keynote presenter, there's a technology issue and we session will be resumed in a few minutes. He's joining us. So please wait for a few minutes.
Rafkat, can we take around 10 minutes prayers break if there's connectivity issue?
Yeah, I think he's back. Yes. Again, welcome, sir.
Wasim sir, we can see you.
Ji, sorry for the inconvenience. I am just opening the presentation. इसी में ऐसा email.
As well. हम तो ये देखते हैं कि रेगुलेटर जो है वो हमें हमेशा कहता है कि आप ही गलत हो, तब हमने देखा अच्छा फाल्ट रेगुलेटर के एंड पे भी आ सकता है। तो ये
जी. Okay, yes. ये रफका साहब, ये आपको
Yes.
नजर आ रही है प्रेजेंटेशन?
अभी आपकी सामने स्क्रीन आ रही है, जो आपकी फाइल अभी ओपन नहीं हुई.
Okay. Yeah. Here we go. Okay.
Yes, now we can see your presentation.
Sorry. So we can start. Bismillahirrahmanirrahim. So we will start from where Zora has left, and I think we will not be repeating the things which we have discussed already, which were about the role and the liabilities, and I will focus more on those areas which we are supposed to cover in respect of the state-owned enterprises or the public sector companies, how the independent directors are so this is the outline which we are going to discuss today about the best practices, the objectives, and what is the role under the OECD guidelines, what is the status of compliance and the challenges, and a few court cases as well. So we start with the definitions. I think it would be advisable to mention a little background, what we are talking about and how it relates to the independent directors. Basically, SECP issued the Public Sector Company Rules 2013, and wherein the idea of independent directors was introduced for the first time for such class of companies. But the practical scenario is that the independent directors were there much earlier in respect of the public sector companies. For listed companies in 2002, the concept of independent directors was introduced. And very lately in 2013, the public sector companies, the independent directors were for the first time that was made part of the regulatory framework. But practically what we have seen in the articles of association of many companies, the public sector companies, the idea of independent directors was there much earlier. And what was the reason behind that? The primary reason was that in the listed companies, the independent directors are primarily inducted to have an oversight over the interest of the minority shareholders. But here, in case of public sector companies, the primary reason is that they are taken on board for the reason that they have certain expertise in the sectors to which the public sector company relates. So the notion of independent directors, or for that matter, the minority investors, which are not there in large number in case of a public sector companies. So the major reason is for the boards of public sector companies is to gain benefit or advantage out of their expertise in the line of business in which the public sector companies is operating. So we have a large number of public sector companies like the listed companies in different forms, in different classes of businesses. There are SOEs under special enactments. There are public sector companies registered under the Companies Act. And whether they are working at the federal level or at the provincial level, then there are even public sector companies which are not commercial. They are working with objects which are not for profit. So there are unique challenges and unique, you can say, the roles which the independent directors are supposed to play in case of public sector companies. Here, the thing which differentiate an independent director from the independent director which is working in a listed company board is that the independence has to be exercised from the government as well as from the company, the enterprise. So these are the two parameters on the basis of which the definition of the independent directors for a public sector company has been drafted, and it takes care of both the elements. He has to be independent from the company or the state-owned enterprise as well as from the government itself, whether in the capacity of a civil servant, a joint secretary, or an additional secretary of the line ministry. He shall not be a public office holder. He shall not be an elected official or a parliamentarian. So all these characteristics are required for an independent director if he is allowed, before he is allowed to work on the board of a public sector company. And again, as already Zora has explained, that there has to be such individual has to be free from any material interest or relationship, whether from the company or the enterprise, from the management, from major shareholders and other stakeholders, which can jeopardize the exercise of objective and independent judgment. So what are the cornerstones or what are the basic pillars of good corporate governance? As we can see here, these are accountability, fairness, transparency, and independence. So here, the independent directors, not only the board has to be independent in totality, because the line which is drawn between a shareholder as principal and the board as a collegiate body, as an agent of those principles. So there are two elements: one as the independence of the board as a whole, and then independence as an individual, which a board member, an independent director, is supposed to possess. So you can see that independence is one of the cornerstone or the pillars of good corporate governance here. And another objective is that independence has to be exhibited not only in letter but in spirit. We have seen, based on the experience we have, the regulatory experience, we have seen that we have a sizable number, a good number of companies which are complying with the numbers which is required under the law. Like we have a requirement of 1/3 board members to be independent, minimum of 1/3. So there is a good compliance position, as we will see in the ensuing slides. But practically, based on the feedback we get from the companies or the independent directors themselves, there are a lot of issues which arise from the exercise of independence in true spirit. Basically, it is a state of mind. It is not something which is like an institutional mechanism. It is more about ethics. It is not only about thinking from the mind, but it is about application of ethical values and principle. You have to think from your heart in many cases if you are supposed to exercise independence in true spirit, because it is about avoiding the conflict of interest and many such things which require the application of ethics and the applicability of principles vis-a-vis the rules. Basically, it is what Zahra has explained. It is more about the application of a principle-based approach as against the rule-based approach. But here, what we have seen based on our regulatory experience, we follow rules more in letter but not in true spirit, and that's the reason why the institution of independent directors is facing challenges despite being there since almost 2 decades. So what is more special about the SOEs? is that there are certain unique challenges which an SOE may face. And again, independent directors are supposed to exercise extra due diligence in such companies as against the listed companies. Although we can compare a listed company with a public sector company in many different aspects, like listed companies has a large investor base, but here in public sector companies, we see that every person who is a taxpayer is an owner and investor in a public sector company. So what we see that there is a diffuse ownership here, and very large investor base. You can see here not only the registered shareholders, because here the government being the shareholder is working in a fiduciary capacity on behalf of the citizens and the taxpayers. And again comes the challenges which are unique to such companies, like misuse of public money, corruption, and things like that. And for that reason, the independent directors, their role and responsibilities are elevated to a certain degree, much bigger than those which are required or which are supposed to be exercised by an independent director in a listed company. Then again, state-owned enterprises or the public sector companies are supposed to observe high standards of transparency, just like listed companies. They are supposed to follow the IFRS, just like any other company. We have a lot of state-owned enterprises which are registered as private companies. But again, the public sector company rules require that they are supposed to follow the IFRS, because they are public interest companies. It is immaterial, it is secondary that in what form of business or as what class of company they are registered. They may be registered as private limited or a Section 42 company or a public unlisted company as well. But irrespective of the class of company within which they are registered, they are supposed to follow the highest level of disclosure requirements and the compliance requirements under the Companies Act and the relevant rules and regulations. So a landmark case I would like to share with you, which happened back in 2015. And on the back of it, there was an event. There was a major power breakdown in the country, on the countrywide power blackout. And that was a public sector company, the National Transmission and Dispatch Company Limited. So what the government did, it removed the managing director, the CEO of the company. And against that decision, one of the independent directors moved the court, the Islamabad High Court, and challenged the government decision. And that was a landmark decision because the Islamabad High Court reverted the decision of the government and reinstated that person to the position of the chief executive. And incidentally, the person who moved the court, who was independent director at that time, today he is one of the judges of this particular court. And basically, the issue is that the principle which was kept in view by the court while giving this decision was that the accountability of the management, which the CEO was, he was sitting at the top of the hierarchy of the management. So the accountability of the management, whether it's the person at the top or any member for that matter, any member of the management, it is the prerogative of the board of directors and not the shareholder. And for state-owned enterprises, one of the most important determinants of the success is the independence of its board and freedom from political intervention. So even a few more cases discuss the appointment of the CEO, the appointment rights of the which are supposed to be exercised by the board of director and not by the shareholder. So things went moving. Then comes 2017, after which the powers to appoint the CEO was assumed by the government itself. And again, in the same year, the Companies Act 2017 was enacted, and that proposition was made part of the substantive law. And right now, both the board of directors as well as the government have the powers to appoint the CEO. But I was just sharing this particular judicial interpretation with you to highlight the importance the independence can play in the affairs of a company and in the operations of the board of directors. So these are a few more things whereby you can differentiate between the public sector and private sector governance. And from these differences, the roles and responsibilities as well as the liabilities of the independent directors can be drawn. And as you can see, and as I have explained earlier, that there is diffused ownership structure. The organizational structure is too varied in case of the public sector. We have a lot of authorities, government departments, SOEs, companies, entities working on PPP model. So there is a large diversity within the public sector, unlike the private sector or the listed companies, where there is just outsider or insider model which is being followed. But here, because of the diffuse ownership structure of such companies, the public sector companies or the SOEs, the challenges are bigger. And again, for that matter, the importance of the role of independent directors assume more, you can say, it becomes more important for an independent director to exercise his role and responsibilities within a public sector context. Then we have company law as well as special enactments. The agents for director of a public sector company is the whole public, unlike a listed company, which are just the shareholders and a few more stakeholders. The objectives is public good as against the profit. The major objective, which is listed for a listed companies, profit making, but here it is the public good and protection of the interest of all the stakeholders. Then the authority is the board in case of a listed company, but in case of an SOE, it is the appointing authority, which is the government itself. Because under Section 165 of the Companies Act, the government has the prerogative of appointing all the directors, whether he is a independent director or an executive director or a non-executive director, and such directors work at the pleasure of the appointing body, which is the government. Then again, as I have said earlier, the responsibility is diffused for such companies. The independence is exercised on the basis of the ministerial control, and the accountability is again diffused. So when we come to the individual board member, we can see for a public sector company, there are multifaceted role which has to be played by a director, independent director, whether he is independent director or not. In an SOE, the stakeholders are larger in number. It is the shareholder, it is the government, it is the public at large, there are customers. Then there are community obligations in the form of CSR. Then he is accountable to the chairman and as a member of a collegiate body, to other board members. At the organizational level, he has to interact with the senior management, not so with the staff, because he's not supposed to micromanage the things. So although the executive directors are supposed to interact with these people, but as independent director, he has the role which he is supposed to play is may involve interaction with the senior management, other board members, and all the stakeholders which are external to the company. On a lighter note, because we as accountants know, there is a famous saying that what the HR people says, that people are our greatest assets. But an editorial which was written says that just to create the balance sheet, sometimes the liabilities which arises for a company, whether it is a private sector company or a public sector company, the liabilities are lying on the board of directors. So this is a fact. This is not just on a lighter note. But while the human resources are the assets in today's world, but again, the same human resources, if they are sitting at the top of the hierarchy, if there is no tone at the top, they can become liabilities for the whole enterprise itself. So coming to the legal provisions, although we have explained a little bit earlier, as Zora has explained, that definition of independent directors within the Companies Act or within the public sector companies rules is almost identical. But here I have just drawn a difference between the subjective test vis-a-vis a few objective tests, because in certain scenario, we frequently receive queries or in certain cases complaints about the exercise of independent judgment by the independent directors, whether or not they are crossing the limits of independence, whether they are observing the conflict of interest situation, whether they are perceived or apparent. So what we can see is that we have first to apply the subjective test, which is more difficult to apply because these are not numbers. This test is more about the application of you can say ethical principles. Then comes the objective tests, which are more about the numbers, the number of years and the relationship, as Zora has already explained, that it is more about the mechanism, how and what you have said, that the numbers as well as the relationship with the company. So objective tests are like covers these sort of parameters. Then there is a cooling off period, like after 2 terms of serving as an independent director, he has to take a leave for 1 term. Then again, he can join the company for the 3rd term. But although we don't have the numbers like Zora has presented the Indian scenario, that the independent directors are there for so many terms of office or so many years. But this is what the law requires: 2 consecutive terms, then there is a cooling off period, and then he can join the company for another term, for the 3rd term. So all these are the objective parameters which are supposed to be taken care of by the appointing authorities. And again, what we have seen, as we will see in the ensuing slides, so what happens when these parameters are not followed? Not only the independent director himself has to bear the brunt because when there is an allegation of corruption in that particular company, so many things open up, whether the persons who were sitting on the board, how they were appointed, and basically it is appointing authority who has to undertake this due diligence, which has to make it sure that all these criteria of objectivity and independence have been taken care of. So in certain cases, they come to us, appointing authorities, the line ministry comes to SECP and other regulatory authorities. They ask from us whether this particular person whether or not there are any adverse remarks or any adverse position in other companies which he is in which he is working as a director, whether independent director or as an executive director. So many things have been taken care of at the time of appointment, and the and the appointment, because now it is more in a structured format after the introduction of section 166. The whole mechanism was formalized. There is a data bank, and there is a sort of assurance from the appointing authorities that certain things have already been taken care of by the institution which is administering that particular data bank. And then there are certain protocols to be followed, and then there is a liability upon the potential director himself that he has met the criterion which is supposed to be followed. So now things are now more transparent, and it is now more easier or facilitative for the appointing authorities. But still, there might be certain circumstances where such persons may face the risk of a liability in case of anything going wrong, or any sort of allegation of corruption, or any media report coming before the public, or any inquiry, or any even whistleblowing act of any person who is aggrieved by any act of the company. In many cases, we have seen such whistleblowers going to the court or coming to the regulator for the reason that his concerns were not addressed. And in many cases, we have seen such scenarios where there were frivolous or vexatious allegations against the company or the board of directors. And after inquiry, it was found that such allegations were not holding the ground and were not justifiable. But again, it may create a problem for the board members as well as the appointing authorities. And so the spirit, what we are saying here is that these objective tests are supposed to be followed in true spirit. And again, the subjective test, avoidance from conflict of interest, that those also are supposed to be taken care of by the appointing authority. So in 2013, the rules were first introduced, which required a majority. During the first 2 years of the rules, it was required to have at least 40% of the members to be inducted as independent directors. And then going forward, within the next 2 years, a majority was required. But before this 4-year period was completed, there was a change in the law. First, within the rules itself, which required a minimum of 1/3 of total members as independent directors. And this particular provision was taken within the substantive law in the Companies Act itself, which require the independent directors to be inducted based on the threshold which is provided within the relevant framework. Like in the CCG regulations, again, there is a requirement of 1/3 and board members as independent. And also we do have already within the rules, but this particular requirement was somewhat diluted in 2017. Although it says that not less than, it may be 100%, it may be 50%, or any threshold beyond 1/3 requirement. But there was a sort of facilitation. And what were the reasons behind that? We will discuss it later in the ensuing slides. There was a limited availability of independent directors. The pool of experts was not available to take care of all the companies in the public sector or the SOEs. So this was one major change in 2017. And the other change was that the chairman of the board was earlier supposed to be elected from amongst the independent directors. So this requirement was done away in 2017. And now the board can elect any person as chairman of the board of directors. And one more change that was made was that now the government also has the authority to directly appoint the chairman of the board of directors. Then again, another change was in the composition of the board committees, which earlier required a majority to be independent. And then in 2017, this requirement was done away with. And now it says that independent directors shall not be less than their proportionate strength in the committees. And now they can also be chaired by the non-executive director, which requirement was already there in 2013. A few global best practices I would like to share with you. This is based on an IFC World Bank progression matrix. And we can see where we are right now. Level 1 is the lowest level and level 4 is the highest leadership level. And so far the expertise is concerned, the first level says that the board shall include non-executive members with certain commercial and financial experience. And then it progresses to a level where level 4 says that the board is dominated by members from the private sector. So right now we are lying somewhere in between level 3, which says that a significant number of formally independent members. So I think 1/3 threshold is classified as a significant number. But in many countries of the world, there is a requirement to have majority of independent directors. Like we had earlier in case of public sector companies, a majority was required, which was later diluted, and now it is a requirement of having 1/3 member. So we are lying somewhere in between. The next parameter as far as the independence is concerned is that the board oversees key activity, and the role of the government in approving or guiding the key activities is clear. So this is just the very basic requirement. And at the far extreme, what we see is that the audit committee has all the independent members and primary authority over internal audit. So what we see here is that the role of the government is diluted. And practically what we have here in Pakistan is that we don't require all the members of the audit committee to be independent. But what we have seen earlier is that all the committees, whether it is audit committee or otherwise, it has to follow the proportionate strength. What we have seen is that is 1/3. So again, in the case of audit committee, the 1/3 threshold is supposed to be followed. But the chairman of the audit committee is supposed to be an independent director. So this is one thing which is over and above the requirement which was earlier provided. Because in case of other committees, like we have like under the public sector company rules, we have procurement committee, we have HR committee, the risk management committee. All such committees are not supposed to have the independent director as the chairman. But here in case of the audit committee, there is a requirement that this particular committee is supposed to be chaired by an independent member. Then again, we have the requirement of board members seeking to avoid conflict of interest and declaring such interest to the board. And then it elevates to a level that the committees with independent members oversee such areas as remuneration, nomination, and conflict of interest. And finally, the board has the full authority and autonomy as provided in the Companies Act and company law and the practices as prevalent in case of such companies. So on keeping in view the instances on a countrywide basis, majority of the OECD countries are having majority of SOE board members as independent. In other countries like Korea and Mozambique, again, there is a requirement of having a majority. Countries like us, like in India, they do have a requirement of at least 1/3 of board members as independent directors. Then again, in France, there is a requirement to have 1/3 members as independent, and they have even specified the other classes of directors as like 1/3 employee directors and 1/3 as government representatives. In Indonesia, there is a requirement to have 1/4 requirement for independent directors. In other countries, the non-OECD countries, and in addition to those which we have discussed, like in China, the requirement of independent directors is not specified in percentage terms. Then in Egypt, there is no formal requirement. In Korea, more than half of the directors are supposed to be independent. In Malaysia, no formal requirements. Then in the developed countries like Sweden, there is a requirement to have 90% board members are supposed to be independent. And then there are other parameters to assess the board efficiency or the board composition, the optimization of the board composition process. State representatives are not required in a large number of countries like in China, Egypt, Korea, Sweden. Employee representation of the board is not required in majority of the countries, except a few like in Egypt and Sweden and Vietnam. And then rules guiding board diversity are required in certain countries, like having gender balance, nationality, or locality. Few countries have specified such rules, but a majority of the countries have not specified such requirements. Insofar the diversity is concerned, our public sector company rules just give a general principle that the board has to ensure diversity, and again it is the appointing authority which has to take care of this principle of board diversity, and this has been taken care of not only within the public sector company rules but within the code of corporate governance regulations as well. Then a few more case studies like reducing the participation by government ministers and other high-level public officials. A few countries have specified certain requirements, like in Estonia, the ministers can serve on the board of certain public sector foundation, but not the companies. Here in Pakistan, we have a requirement that in case of independent directors and even any other director, no public office holder can become a director in a public sector company. This is the requirement provided within the fit and proper criteria, which is part of the public sector company rules. Uh, Other countries like Slovenia, they require that public officials cannot serve on SOE boards, and not more than 2 civil servants can serve on a supervisory board. Supervisory board is this is a structure which is followed in certain countries. There are two-tier board structure. One is the supervisory board, and then there is the management board. And here in Pakistan, we have not two-tier board structure. Within the same board, we have already independent directors as well as the other classes of directors. So there is no need of having a supervisory board. And the countries which are having a supervisory board structure, that comprises primarily the independent board directors, or the board members don't need to have such structure, but in many continental European countries, so this is just a minute. I'm sharing the screen again. So we were discussing the different stances of based on the global best practices which are followed in certain countries relating to uh, the public officials on the boards, the skill sets or the expertise which is required from the independent directors, and all sort of such things. One more thing which would like to discuss is the OECD guidelines. These guidelines were earlier issued in 2005. These were revamped in 2015, and guideline number 7 deals with the responsibilities of board of directors. These were substantially revised in 2015, and although the original rules which were formulated, the public sector company rules, they were based on the 2005 version of the guidelines. But after these guidelines were revised in 2015, although we have not reassessed the public sector company rules against these revised guidelines, but the rules already substantially take care of the best practices or the principles which have been specified through these OECD guidelines. So the overarching principle on independence as contained in these guidelines, this said that the state should avoid interfering in the operational matters and thereby respect the independence of the board. Then there are certain details or certain explanations, certain annotations on this basic principle, which have been provided within these OECD guidelines. Like within the guideline number 7, which is about the responsibility of the board members on independence, what it says that, and what are the new things which have been provided within this 2015 version. It says that independent board members should be free of any material interest or relationship with the company or other stakeholders. One more thing which was newly added is that particular measures should be implemented to prevent political interference on the board of state-owned enterprises. And then there is a growing consensus that certain public sector representatives should not, under any circumstances, sit on SOE boards. Like it may be the parliamentarians or other public office holders, because of very clear conflict of interest in case such persons sit on the board of directors, then it can jeopardize the whole governance arrangement within the SOEs or the public sector companies. Then the role of the chairman of the board of directors has been elaborated in greater representation. OECD guidelines, objective, the exercise of objective and independent relationship with the enterprise. Again, we have discussed it earlier, and mechanism to ensure objectively carrying out the board duties and to limit the political interference in the board processes. So these are a few numbers which I would like to share with you. We have discussed the requirement like having at least 1/3 board members, the public sector companies. So this data is based on the recently published SOE report published by the Ministry of Finance. It is also available on its website. So as you can see, in case of commercial SOEs, these are the SOEs, state-owned enterprises. Majority of these are public sector companies, but a few more SOEs which are not companies, like those registered under special enactments. And as you can see, almost we are meeting the threshold of 1/3, 30% of the board members are independent. The rest are either executive or non-executive. But one thing which is notable is that if you combine the non-executive and independent element, it comes to around 80%, which is a very good figure. And what we see here is that executives occupy only almost 20% of the total board strength. So this is a healthy figure. Again, for non-commercial SOEs, which by which we mean the Section 42 companies, the association, not-for-profit, and then certain SOEs which are working for commercial purposes, like there may be certain like universities or other government departments which are not working for profit or for commercial basis. Again, here the requirement is the same for all the public sector companies or SOE. It is 1/3, and again here is the threshold is met. It is almost 29%, the same as the almost identical to 30% threshold. A little bit lower than the 1/3 threshold, but I think it is largely, we can say it is the requirement is largely met. Another thing to share, there was a survey in 2016 about taxes bigger, but the companies which act what comes out, the 90% of the directors were either non-executive or independent board members, and the CEO director. So this particular inference or the finding is supported by the recently published SOE report by the federal government, where we have seen that almost 80% of the board members were non-executive. Certain unique challenges which you can see that the first and foremost challenge is the box ticking approach. Not only the application of objective parameters, but only the subjective approach needs to be applied. And the appointing authority has to see in true spirit whether the independent directors who are appointed to the board, they are exercising independence in true spirit. Like in one particular case I can share, but we have seen that in a particular company, the chairman of the board was also appointed as a chairman of all the committees of the board. Like we have 5 committees here under the public sector company rules. So there is a requirement that independent board, the chairman of the board, and he also supposed to be independent board member, like in the case of audit committee. So he's not supposed to run the day-to-day affairs of the public sector company. So this is what is required from the chairman. But what we have seen is that by virtue of being a member of the board committees as well, which are like 5 in number, as well as on the
important. And I was back.
Sorry, we disconnected again. Rafkat Saab, I think we don't have missed a lot of what we were discussing. So we were discussing the challenges which are faced by the appointing authorities as well as by the directors themselves and even the regulators as well. The next challenge which the appointing authorities face is the limited talent pool. Not many people are interested in joining the companies as independent board members. There are many reasons because we know are sitting on boards, and again there is a limit for that. Like a director cannot sit on more than 5 public sector companies. So there are limits which have been defined. But the limited talent pool, there are many other reasons which are responsible for this dilemma which we are facing. Like we have seen in the media, and even based on the experience, the regulatory experience, we have seen that many cases are there in the courts where independent directors are made party for certain acts of corruption, which comes to the any stakeholder come to the court, and there are allegations on the board member. Primarily, these are the board members, which are the governing body members. They are responsible for running the fairs or supervising the affairs of the companies. So many cases are there where we have seen that investigative agencies are inquiring or they are probing the affairs, and they are again naturally they will ask from the board members what had happened, like what were the discussions that were held for a particular decision that was made in a board meeting. So again, there is a reputational risk for working on the board of public sector companies. So that is a cause as well as an effect of having limited numbers of board members as independent board members, because the challenges or the risks are greater.
Yes, Azim. I think there is again technical problem at SCCP end, and we might have to wait 2 minutes. Azim, can you hear us? The next session will be very important. That is the question and answer session. So please stay with us so we can ask the questions we have already posted, and we can also post the questions meanwhile. Our speaker is trying to reconnect, so please wait a few minutes. Yes.
Yeah, I'm back again. Sorry for the interruption. So we are just approaching the final slide. So these are a few challenges which we have discussed. We have discussed the litigation challenges, the litigation risks which an independent director may face. Verification of material related party transaction. This is something which is essentially required from an independent director. And I think that besides all other agenda for discussion coming to the board meetings, this is something, because it is very much essential to have a look in detail on such transactions, because it is through these transactions that the interest of the minority shareholders are, particularly for a listed company, not so for a public sector company, but in case of a listed company, the related party transaction have to be probed, and an independent director has to take care of, he has to ensure that there is no element of tunneling or any abuse of uh, the transactions, so that the interest of the minority shareholders are not compromised. Then there is a risk of micromanagement, which uh, an independent director is not supposed to exercise. He has to look at the big picture and the broader issues. A few more challenges, like the Enron scandal, which Zohra has already explained. And in all these cases, there was a large component of independent directors, but in all such cases, they fail to exercise independent judgment, or they fail to ask out of fear, which Zora has already discussed. They fail to ask candid questions, or question the management, uh, or exercise the roles what was expected from them. So they have to give their voice to the board proceedings. So it is more about the quality of independence, which matter more than the numbers themselves. Having 1/3 or more than 50% or a majority is secondary to the quality of the independent directors. So it is basically the expertise or the business acumen which is more, we can say, essential for that than just meeting the.
I think again we have connectivity issue from your end. Can you hear me? Once again, I think he's disconnected and trying to reconnect. So please bear with us.
Dr. Saab, if there is a connectivity issue, we can request them to be on the voice mode only, and we can go with the question and answer sessions if they have some connectivity issues or video sharing, etc.
You are right. I think once the presentation is over, let's see that if they close the window screen, is there any improvement? If not, then we'll go for voice only. Wait for the reconnection. Welcome back.
जी हो गया, now I'm connected. जी Rafka Saab, can you see me?
Yes, yes, very much, sir.
Can you hear me? Okay. So we are on the last slide, just the future reform agenda. There has been a development. Last week, the federal government has approved the draft State-owned Enterprise Act. And as far as the independent directors are concerned, what has been proposed is to have is a requirement to have a majority, and the rest of the provisions are almost identical, which are provided within the public sector company rules. So this exercise, the drafting of SOE law, it almost took more than a year, and it was primarily a requirement of an IMF Memorandum of Economic and Financial Policies. So it was one of the deliverables, the drafting of the SOE law. And then there are other requirements as well, like the development of a triage. But insofar the independent directors are concerned, almost majority of the provisions, they are like a replica of the public sector company rules. But a few bold steps have been taken, like the development of an ownership policy, which was not there and which was even not possible within the public sector company rules. And this was one of the demands as well as the observation of many IFIs that Pakistan does not have an ownership policy. All these things, the element of independence, the exercise of good corporate governance, these are not possible. But we have seen over the last couple of years that unless the government has a clear-cut policy and ownership policy, which will define what is supposed to do and what it is not supposed to do, unless that thing is in place and that is properly exercised and in true spirit it is exercised, the remaining provisions, whether they are robust enough or not, these are cannot be, you can say the results cannot be achieved in at a level what was envisaged at the time of introduction of all these reforms. So this is an agenda for reforms, and the independent directors, the requirements are there. A majority is not required. The disqualification criteria has been specified. So we hope that with all these reforms, we will elevate to a higher level of true independence and exercise of corporate governance principles in true spirit. So this is all from my side. Sorry to say that I have taken more of your time, partly due to the frequent interruptions or the lack of connectivity. So I think Rafkat Saab, over to you for the questions and for the patience. Thanks for the patience of the audience and all the participants and all of you.
Thank you, Senior.
So now the floor is over to you.
Thank you for sharing detailed insights on overall requirements, role, responsibilities, and liabilities of independent directors in case
I
of
think you are muted.
public sector companies. You can hear me? Shahid, you can hear me?
Yes, it's clear.
Yeah. So again, I think problem at SCPN, but senior especially sharing that why people are reluctant to join boards of public sector companies. And I expect that you will share something in question answer session that is there any development on this element to counter these that independent directors of public sector companies could now be part of court litigation. So with this, dear participants, we are moving to another very important segment of question answer session, and that will be moderated by our chairman NRC, Mr. Shahid Iqbal Khattak. Shahid sir, over to you.
ठीक है, मैं
Thank you,
available
Rafkat.
रहूंगा.
Thank you, Rafkat, for giving the opportunity. Grateful to Wasim Saab, Zora for giving an excellent presentation. When this seminar was planned, I was excited that there is entire 2 hours question answer session, which I'll
Sorry, sir, we are
moderate.
not getting your voice.
Is it okay?
My voice is very much clear. I think Wasim, there is again connectivity issue at your end, and if you consider mute your video, so that might improve.
Sorry, can you repeat?
Yes. Okay. So is it clear now?
Yes. Yes, please.
Okay. So thank you, Wasim Saab. Thank you, Zora, for giving excellent presentation. I was just sharing that I was extremely excited for this session, which I was expecting that the question answer session will be 2 hours. But unfortunately, I'm left with 30 minutes and I have a lot of questions. So, okay, we will try to respond to most of the questions we have received from participants and something in our mind, which the participant would like to get clarification. So the very first question is that you just referred that SOE Act 2021 is in draft phase and the government is planning to enact very soon. So is there any sort of stakeholder workshops to be planned? Because it's very exciting to give our input. There are a lot of challenges in the existing public sector rule. So is there any workshops or stakeholder sessions planned for this?
To my knowledge, no such awareness session has been held because it has been passed last week, I think, by the federal cabinet. And before that, I think for 6 months, it stayed with the Ministry of Law, and through the Ministry of Law, it went to the Cabinet Committee on SOEs and CCLC, the Cabinet Committee on Legislative Changes. So basically, there is no public discussion on the draft, but we are in receipt of a few comments from certain line ministries. But obviously, there has to be a public debate on this, and for that to happen, I think the Ministry of Finance, being the lead ministry on this project, it has to ensure that there are certain discussions before the law sees the light of the day. There has to be a discussion on all the components, which because there are a lot of new things besides all the things which are sort of replica of the public sector company rules. But there are a lot of new things like the ownership policy, the sound and prudent management policy for the management and the board members, a lot of new things which are supposed to be discussed in detail before the law is promulgated.
Okay. It's really encouraging even that the government is considering enactment of this law anyhow. So very important question. The independent director scenario is increasing over the period. What is the basic reason? Did ACCP observe any improvement in performance of public sector companies or listed companies with the introduction of these independent directors?
This is, I think, a difficult proposition. There have been a few research studies, but I think there is no uniformity or you can say consensus of the opinions or the findings, which says that it's not about something which is directly proportional to the, like if you under 2 or 3 independent directors, there is a marked improvement in the financial performance. Even introduction of the corporate governance framework, overarching framework, which takes care of many more things in addition to the independent directors. But the market feedback is that there have been improvements, and there have been few findings or you can say conclusions, like the ROSC study. It is one of those studies within which it has been commented that there have been improvements in the way the companies are operating or the governance arrangements are being followed. Although you cannot directly relate to the financial performance, because that is something which is beyond. For that, there has to be a thorough research or study which links up with the financial performance of the companies which have adopted the corporate governance principles. But indirectly, we can say there have been improvements. but these are not quantifiable.
Exactly. But it's the same. The independent directors, they don't have any stake in the company. And it's the same, they assume a lot of responsibility. So it's a mixed sort of approach, because the management is fully responsible for operations. When they submit to the board and they say we are independent, we don't know the operations, they don't give approvals. It's the same, the company suffers, and the board, if they are aversive. Otherwise, if they are aggressive, they take decisions at the cost of the management. So the question is independent directors really concerned about the affairs of the company?
I think they are supposed to be concerned about the phase of the company, but they are, as I have said it earlier, they are not supposed to micromanage the things, because they are in case of public sector, like they are primarily supposed to provide their insight, the business insight they have with them, because the other people who are sitting on the board, like there is a secretary from the line ministry, then there are executive board members, or any nominee directors from holding company, or any associates of the public sector company. Normally they are not used to exercise the business judgment or business acumen. So for the public sector companies or the SOEs, it is the business expertise, and they shall apply their knowledge and the expertise while making business decision for public sector company. And I think for listed companies, if Zora can add to this, I am of the view that again they have to adopt a balanced approach, and primarily their responsibility is to ensure the protection of the interest of the minority shareholders and the interest of the other stakeholders in a broader perspective. So they have to look at the big picture. And like I have quoted the example of related party transactions. So this is one of the things which is most abused in like listed companies, and specifically those companies which have large groups. So for those types of companies, they have to ensure that all the transactions they are truly fairly being recorded, and there is no abuse of the information which the insiders or the controlling shareholders have with them. And these are the things which I think they are supposed to take care of. Zora, if you would like to add something.
Zora, if you can please add on what independent directors are they really contributing to the family-owned businesses? Do they have a say? This is question number one. And question number two is, do you consider appropriate that the executive heads of the department, say chief technical officer, chief financial officers, they also need to be on the board to give their insights? Your views, please.
So what Shahisab is asking that, I am discussing it with Zora as well. Basically, the question is that what is the contribution the executive directors can make to the overall the value they are supposed to add to the business decisions. So for listed companies, I think even for the public sector companies, there has to be not a sizable number, but a respectable number of executive directors, because being the insiders, because the rest of the people, whether they are like for PSC, they are ex officio board members like secretaries, or the independent directors who are not aware of the company, what is going inside the company. So executive directors have to be there, and they have to provide the insight or the feedback to the outside board members. And unless they perform their due role, I think overall in totality the business decision cannot reach at a level that that translates into the maximum value for the company, whether it is a listed or public sector company. So they have to be they has to be there, and they have to exercise their role in the maximum possible beneficial manner to the company.
Yes, Zora, please. What is protection to the independent directors is their civil liability is same as other directors? Because they consider themselves as independent. So can you please explain what is the level of liability of independent directors as compared to other directors?
Okay, so there's a specific section which I mentioned in my presentation also, as section 181, which provides protection to non-executive and independent director. But there is a caveat to that, and I'll just read out that part where where it says that they shall be held liable only in respect of such acts of omission or commission by a listed company or a public sector company which had occurred with their knowledge, attributable through board process, and with his consent or conveyance, or where he had not acted diligently. So this is the main part which is seen when we are fixing the liability, the participation in the decision making vis-a-vis the other directors, and the consent of approving such matters.
All right, thank you. Wasim, the director's fee in case of these public sector companies mostly established under Section 42, is there any provision to pay them the meeting fee, directorship fee, and is there any limit to that?
There is no defined limit, but they can, like all the directors, whether they are from the government or not, they are entitled to the remuneration to of meeting fee and out-of-pocket expenses like traveling, lodging cost, not beyond that. Because particularly for Section 42 companies, there are added restrictions because they are working with the charitable money, which the stakeholders have provided to them. So there are additional protocols for them to follow for Section 42 company, and even if they are over and above, if they are public sector company, their requirement to get them restricted to the payment of the meeting fee and the out-of-pocket expenses. Sir, you are muted, I think.
In public sector companies, we have observed very large board consisting of say 15, 20 something numbers. So do you have any sort of idea to restrict the limit to ideal size, say 7, 9, 11 something? Is there any restriction on that? Does SSCP consider while approving the articles of association for such numbers? And is there any right composition of independent other than the minimum limit?
Actually, it is up to the appointing authority, being the shareholder, to decide what is going to be the optimal board size. But the instance you have quoted, I think this is not a norm. It is maybe an exception. We have not seen boards. There might be a couple of or handful of companies, such companies, where the board is of such a large size. But if the board is of that size, it is not advisable, because such companies, if they are running on public exchequer or the public money, and although they are not supposed to draw the benefits, I am not sure whether it is a Section 42 company or not, but even otherwise, if it is a commercial SOE or public sector company, they are not supposed to take the undue benefits, because even in case of meetings, even if you are holding a meeting right now, although we have now the facility of online meetings, whether it is through Zoom or WebEx, whether you are sitting outside the country, you can attend a meeting. But even otherwise, they have to exercise proper diligence. And regarding specific to your question, we cannot specify the maximum number of directors. We can just issue an advisory or sort of informal advice. But again, it is up to the shareholder or the government, being the line ministry, to decide what is going to be the optimal board size. And they have to justify the things. What are the reasons behind having such a large size of board? The board members, if they are so large in number, there has to be certain justification for that.
Sir, the justification is pretty simple. We need to accommodate the people anyhow. That's a personal remark. Sir, the very important question with respect to public sector companies management, you referred a judgment of 2014 where independent director contested against the government. But in these, the public sector rules 2017 under rule 511, you say that the rules say that any directions from the government will be binding on the board. And at the same, we say political intervention should be limited, or there shouldn't be any political intervention. So, and all these boards serve to the pleasure of the government. So if all the directives are binding on these boards, and these secretaries are conveying their directions, how these boards can work independently? This is question number one. And simultaneously, there is another question where these board use the government funds and they say we are independent and we can utilize our sort of authority utilizing the government fund. So how to balance these two approaches? This is very critical and this is significantly impacting these public sector companies' operations.
Very interesting observation you have made through your first question. Actually, it is a cause and effect relationship, basically. The thing which happened in 2015 through that judgment of the Islamabad High Court, what I can say is that translated into the revision of the rules, which says that the board members are supposed to follow the writ of the government. Because once it was challenged in 2015 by an independent board member, and that let the government down. What I am saying is that the court, the Islamabad High Court, the decision of the company was voted and the CEO was reinstated. And at that time, I think that the government felt helpless. How it can go about this? So what it did, because these are the rules of the government under the Companies Act, the rules are approved by the federal government. These are not regulations. The regulations are approved by the SECP, the commission itself, but not the rules. And so the government did what it felt practicable to avoid any such stance where any action it can take to in its own understanding that what it felt that it was good to remove the CEO at that time. And who was to blame for that blackout? It blamed all the responsibility to the CEO, and CEO was appointed by the board. It was not appointed. He was not appointed by the government itself. So what the government did that in 2017, it took took away the powers of appointing the board members. Although the board is also authorized to appoint the CEO, but equally at the same level, the government is also now authorized. So the government assumed all those powers which earlier the only board was authorized, like the appointment of the CEO, the appointment of the chairman of the board, things like that. And the provision you have quoted, I think 511, that the government can direct the public sector company to observe certain rules and regulation, although it was not required, and it does not matter that it is written within the rules, because end of the day it is the writ of the government which matters. So you are right in your observation, I think, and the explanation is that now it is part of the law, not only the rules, but even within the Companies Act, which now empowers the government to appoint the CEO. But one thing, the SOE law, which is now being drafted, and based on all the hue and cry, and rightly the hue and cry was, I think, it was justifiable that it shall not be the government who shall be appointing the CEO. It shall vest with the board. And within the draft of the SC law, it has been vested. This particular power has been vested to the board of directors, not the government.
Yes.
Sorry, I missed your. I cannot recall your second query. You was said that.
Thank you, Zora. If you can comment how independent directors are elected for listed companies, and do listed companies resist their presence and challenge their contribution? Is there any sort of reporting to you? Your views, please.
Sorry, I missed the first part. How the independent directors are?
How independent directors are elected for the listed companies, and is there any resistance from such companies about such independent directors?
Okay, so when the Companies Act came, because it was the previously under the code 2012, the independent directors were appointed, and of course appointed at the pleasure of majority shareholders, which is again another debatable part. But however, because of the requirement of Companies Act would require that independent directors of listed companies would be elected, and the process would start from the company selecting from the data bank. The company would go through the data bank, select an individual which it deems appropriate. This does not mean that an independent director cannot approach the company themselves, who is registered in the data bank, to be able to contest the election. And then the process is same, that the nomination process of other directors, it's the same. The company is however responsible under the law to ensure the due diligence of the person who has been selected. And when the notice of the general meeting in which the election is being held, when it is sent to the shareholders, the company is required to provide the justification for the independent director as to why he has been selected. Otherwise, the process is same. And the second part of the question was, resistance. Yeah. So there was resistance when the new requirement came, because it was about electing. And the first question was that how do we tell the shareholders to elect a certain person as independent director, because there's a certain way of election where the maximum, a person who gets the maximum vote gets elected, and the poor independent director who doesn't know anyone in the company, if he stands up for election, how do we tell the shareholders that you have to comply the requirement of law and you have to have 2 or 3 independent directors, so you have to elect them? So that was the biggest anomaly which faced the companies face practically. And generally, since the requirement of independent director has been there is a general resistance. Just as you even mentioned that the phenomena is, there's always this argument that if the independent director is unaware of the business operations or is unaware of the business environment, then how can an uninterested independent director serve for the interest of the company? So this resistance, to some extent, it is valid, but the notion of independent director is basically that that person is not there to manage the company. It is there to bring wisdom to the company.
All right.
To the decisions of the company, to which is being followed by the company.
Okay, thank you. At the same, Zora, if you can again, the auditor's report on compliance with these public sector, these corporate governance compliance regulations, what are the key, what they should look into, and what are the key non-compliances reported so far if SCCP did some analysis?
Okay. So I don't have the data right now, but this is a very important question, because the statement of compliance with the corporate governance regulation, there's a format given, and the auditor has to give a review report on that, which is and the format of that review report is the audit in the auditor's obligation regulations. Now, the problem is that the auditor's reporting obligation regulation is not updated with the Code of Corporate Governance 2019 comply and explain basis. So it is still on the basis of the whole mandatory 2017 approach. So there's an issue that the review report, the auditor is giving a review report that the company has complied with the requirements of the code as stated in the statement of compliance. What is important is that what we have seen recently is that since the company is explaining in the notes those requirements which were recommended, not mandatory, and explaining the reasons of non-compliance, it is for the statutory auditor, it is very important that they review that part specifically, because the part which relates to mandatory obligation is right on the face of the statement of compliance. But the part where there is autonomy of the company to explain as to why the certain requirements were not implemented, that is the part which should catch the attention of statutory auditor who's giving the review report. And this is the issue which actually we are looking into, that this part can be explained further, and the statutory auditor can also pay attention to that part.
Okay, and last question from you is, I've been posted from participants that a public sector company employee, can he be independent director and any other company, public sector company or listed company?
In any other listed company or?
Yes. Or public sector company, an employee of a public sector company, can he be independent in any other public sector company or listed company?
If he doesn't have any relationship,
I think being in the public sector, they are two different companies. They are not associates. They are not related parties, but they are just owned by the government. The line ministries may be different. They may the same, but the criteria, I think, does not restrict such an employee to.
in letter, no, in spirit.
Again, there's an issue of letter and spirit.
Yeah.
But you would have to see the linkages, if any, which is just by virtue of the fact that both are public sector companies. And otherwise, if they are not related in any manner, I think independence may not be compromised.
Okay, and similar, if I can understand, a director and two public sector companies, they don't, like it doesn't come under the common directorships.
Yes, exactly.
Since our last question, which is very sort of a bit tough as well, these public sector companies, BODs, which are largely run through these independent directors, if they are not performing under the directions or supervision of independent directors, what the government does is they remove certain directors and appoint new one. How can the law which mentioned ineligibility to become independent director, so do they need to report to SCCP about their sort of performance or their reputation, or is there any other platform where such instances can be reported? So my question is, what is the appropriate platform where if someone wants to challenge performance of independent director in any public sector company, and an appropriate action can be taken against that director?
Actually, we do receive such complaints. We have received in the past such complaints where the performance of the independent directors was questioned, whether it was a whistleblower or it was an employee of the public sector company or any member of executive management. There have been cases, even people go to the court of law if they are of the view that, but I cannot comment that whether it was their certain personal vendetta against that person, that independent director, or it was something else, or he was truly acting in the larger public interest, that certain acts of the independent directors or certain decisions of the board members who were independent that went against the larger interest of the company, or like against like there is an HR related issue, the board took a decision which went against the employees at large. So any employee of the company can move the court, and we have seen, I can recall a case where certain employees of public sector company which is owned by a large public state-owned enterprise, I cannot name it, sorry, but because the services of certain employees were terminated and they went against the decision was taken by the whole board, which included the independent directors as well on the board of the SOE. So there have been certain cases which people may come to us, but by and large, they go to the court if they feel their rights are infringed or compromised.
No, so in that particular, this is the last question. So in that particular instance, where there was any action against such board, or it was just the getting those employees the desired their required rights?
I think in that particular case, the employees were reinstated. They were not much larger in number. They were from the senior management, like departmental heads There's a recent case, and even in the past, there certain contractual employees in a particular case they were removed, but those employees were not reinstated because by virtue of being a contractual employee, which is based on the master-servant relationship, any entity or a company can remove any such person who has given his consent in writing that my services can be terminated at the will of the employer.
Yes, Wasim Saab, Ms. Zora, thank you very much for very informative session, and we are grateful to all the participants who posted their questions. I was excited to have a lengthy session, but I'm short of time. So thank you again. Over to you, Rafka Saab.
Thank you, Shah Saab. Thank you, honorable panelists. Thank you very much, ladies and gentlemen, for being patient. I apologize to those who posted questions, but we could not take the question due to time constraints. We are honored to have with us our Vice President, Ali Latif. I think he is traveling all the way. This is convenience of technology that we can join anywhere, but at the same time, I think it's a commitment of our office bearers that they made themselves available whenever we call for our members. So over to you, Latif sir, for your comments, closing remarks. Sir, you are muted.
Sir, you are muted.
Bismillah ar-Rahman ar-Rahim. Thank you, Rafkat, for this opportunity. And I'm grateful to the Northern Regional Committee for providing us this opportunity. And as you already know, Mr. Fatullah Sahab also spoke to you earlier on. We are actually en route from Islamabad back to Lahore. And I regret if you'll be facing some inconvenience due to some distortion. However, I'm regret that I could not be fully available for the webinar, but I did join in the latter part. And I could see the happiness on Mr. Shahid Khatak's face that he got a whole 1 hour for question and answering. And I think a lot of questions, either they were coming in, but I somehow got the impression that mostly were coming from his own heart. So, and I'm happy that all these things are resolved. And I think this is something that take away from this program, apart from the very healthy debate we had on the role of independent directors. I think something good, Rafkat, I think that you should come out is kind of a guide for independent directors. SSCP already has guide for directors, but if we can work with them and actually finalize a paper on the role of independent directors and do that through our research department, I think it would be a great help. And I think SSCP is playing a very pivotal role, and they have really brought about a lot of changes, and they've empowered a lot of directors. But I think on a lighter side, they are shying away from the one of the main things, that this is already a season of indemnity going on, and which one of the autonomous body is also going to get an indemnity. Somebody who should get an indemnity is the independent directors. And we have seen an off and on changes by the SCCP on this area, which is a very sensitive area, that sometimes their veil of indemnity is taken away and then it is again restated back on the hue and cry. This is something we need to actually finalize our thoughts on and have a healthy debate. I'm very happy to say that ICAP has always empowered its members on ethics, and our members uphold the ethics to the highest level. And even under this umbrella, ICAP has also offered an employment loss scheme to its members, in which, God forbid, if somebody resigns due to any by following the code of conduct of IPEC, is insured. And I'm very happy that ICAP would also be taking measures to introduce a kind of an indemnity insurance for our members who are independent directors, which will give them that peace of mind. And I would really like that SCCP also supports such initiatives, in which we will be truly empowering the independent directors. And this would give them that level playing field in which they can take those decisions without the fear of the unknown.
So I appreciated your comments regarding SCCP. Basically, it is the regulatory reforms which the government is undertaking, like the SOE law, is part of that. And there is another task force which Dr. Ishad Hussain is heading, which is working again on the regulatory bodies as well, restructuring and reforms within the regulatory bodies. But insofar the SCCP is concerned, time and again, the SCCP Act has been revisited and it has been amended to take care of the exigencies of the time. So it is never too late, but again, it is the drive normally may come from the government itself, because on a broader perspective, they are having a look at all the major regulatory bodies, and like the grant of autonomy to the state bank or the SCCP or other authorities and other reforms as well. So it is never too late for the government to consider these reform while it is already working on the triage of SOEs, while it would be divesting its investment in a large number of such SOEs, and it would be liquidating, and only those SOEs are going to be retained which are going to deliver or going to add value to the business of the company, although it is said that it is not the business of the government to run the business. But again, it is a good practice, although whether or not it is IMF driven or some IFI driven, it is need of the hour to get away with all the liabilities and only work through the companies which are really delivering and which are smart enough to compete with the private sector as well. So thanks for your comments on all this.
Thank you very much. Thank you very much, Mr. Latif, our Vice President. Thank you very much, our honorable keynote
Thank you.
presenters, Mr. Wasim, Ms. Zora. Thank you, Chairman NRC. Thank you, Jahandev. हमने जब भी SCCP से रिक्वेस्ट की, आई एम ग्रेटफुल कि हमेशा हमें बड़ा पॉजिटिव रिस्पांस रहा, और जब भी हमने कोई वेबिनार करना चाहा, कोई सेमिनार करना चाहा इन पर्सन, तो हमें हमेशा ही बड़ा एनकरेजिंग रिस्पांस मिला. एंड SCCP is one of the regulator, I think, which is doing a tremendous job despite so many difficulties and ongoing relatives. So we are grateful to SCCP guys for joining us. Thank you, our team. Thank you, ID team, and thank you, ladies and gentlemen. Allah Hafiz.
Thank you very much.
Thank you very much. Allah Hafiz.